Greetings, everybody. This is Archangel Macintosh, aka Archangel Michael, Israel, from the 12 tribes of the Hebrew Israelites, Yis-RoyAl, specifically Lawaya, the Haitian tribe, Levi, and also Judah, Yahawada, the so-called Negroes, the Moors, which migrated from Africa, Mexico, to America. I hope you guys are having a fantastic day, and you have already seen part 1 to this video. We're gonna continue on from where we left off on page 19, and I hope you guys have your pen, pencil, and pad ready, or whatever you use to take note. Let's go right ahead and dig right into it. And Security Exchange Commission security, a SEC security. When the commercial affidavit has matured, after 30 days, if after 30 days they haven't rebutted your affidavit and they haven't disputed your affidavit or disagree with anything that you have said in your affidavit under penalties of perjury and your unlimited commercial liability, it is evidence of a debt and or obligations. It is an evidence of debt and or obligation. And you can go ahead and put this in your affidavit. If you do not respond after 30 days, this document becomes evidence of debt and or obligation. In order for it to be classed as a security, it must carry the United States Securities Exchange Commission (SEC) tracer flag on it from the very beginning. And this is important. Very, very, very important. You need to put this on your affidavit as well. As a security, it must conform to the rules governing securities. It must be identified and monitored as such from the beginning. So you want to make sure you put this on your affidavit as well. The Title 15 tracer flag, that's what they call it. I'm gonna show. They're gonna show us an example of it as we go. So just keep it simple for now and absorb what we have already learned. And by the way, make sure you learn the Securities Exchange and Commission's Securities and Exchange Commission rules, because everything you're going to be doing to pretty much collect the debt or sell the debt or anything that has to do with ledgering the documents or turning the documents into accounts receivable will have to be under the rules of the United States Securities and Exchange Commission. You see? So you're going to have to know the rules of Title 15, USC, and the Securities and Exchange Tracer flag. So take note. A ledger identifying the penalties. Since the criminal complaint is in reality a ledger in which the causes of action and the number of accounts are listed and the civil penalties, punitive damages determined, the criminal complaint acts as a punishment tool for wrongdoers who will not repent. And for those of y'all who don't know what ledger is, let me get a definition for y'all. Alright, a book in which the monetary transactions of a business are posted in the form of debits and credits. A book to which the record of accounts is transferred as final entry from original postings. A slab of stone laid flat over a grave. So a book containing accounts to which debits and credits are posted from books of original entry. So the ledger would be like a proof, or account, or a bookkeeping of how much accounts you have receivable, how much documents you are able to convert into monetary value, if you see what I'm saying. Because a ledger is pretty much keeping track, a book containing accounts, how much people owe you based on debit or credit or whatever, and are posted from books of original entry. So whatever you originally put into the your bookkeeping of how much you gave out or how much you are owed is what you're pretty much going after, if you see what I'm saying. So a ledger is pretty much an account stating how much you are owed. Let's keep going down. A ledger is kind of like a diary, but for money. It's a book for keeping track of expenses, profits, and other financial matters. So literally, it's like a bookkeeping. A general ledger is a complete record of financial transactions over the life of a company. The ledger holds account information, a company's main accounting records. So you can call it your record. Your records. So a record identifying the penalties. Should the accused be so foolish as to allow the criminal complaint to be activated? In other words, if they fail to answer by redressment or rebuttal, the war is over. All that remains is collecting the spoils of battle. The accused has lost, and lost in a very big way. In all probability, the accused will never recover from the consequences. This is true because the trial was going on during the 30 days. To compare the commercial affidavit process to a conventional trial would look like this. The commercial affidavit presents the prosecutor's case in one fell swoop. The moment the accused is served, the defense process begins. The accused then has 30 days to make a case. If during that time the accused make no defense nor redress of the charges, he or she then stands convicted by default. And it will be nice if you put that in your affidavit too. Right here. The moment the accused is served, the moment you are served, the defense process begins. The accused then or you then have 30 days to make a case. If during that time you don't make a defense and you do not redress the charges, you then stand convicted by default. So make sure you put something like that in there. It's all important. The trial is now over. The criminal complaint is only a formality to calculate the punitive damages against the accused, which thus have been awarded to the claimant. Accompanying the criminal complaint is the commercial lien, which issued by consensual default. Because after you send an affidavit and 30 days has passed and they haven't rebutted it, usually you give them 3 notices of default. Some people don't. They give them 1 notice of default, which is enough. But 3 notices of default is fair. You see, you're trying to give them time. It shows good faith and stuff like that. And if they don't respond after 3 chances, then they're definitely in default. The lien stands very powerful now and strong. So accompanying the criminal complaint is the commercial lien, which issued by consensual default against all the assets of the accused. So now you're gonna be placing a lien or interest of property or interest on all of their property, their private property, public property, whatever property that they have, or whatever property you stated in your affidavit. You see? So in your affidavit, you must state what you're gonna hold interest on as collateral, because now they owe you something as collateral for damaging you and not rebutting your affidavit or disagreeing with the affidavit. So literally, you can send this stuff to people who don't owe you anything at all, and if they don't respond to it, they end up owing you. It becomes a responsibility through mail, an obligation through mail. This effectively gives the claimant lien rights against all of the property of the accused. Such a lien may be filed in the county recorder's office, your county's deed office. That is where you'll file your liens. However, this filing is not a necessity, but a convenience. Any common law commercial lien will stand by law for 100 years or until the damages have been collected. In most cases, that means practically forever, because the accused does not and probably never will have enough property to satisfy the damages thus assessed. So let them know too, any common law commercial lien will stand by law for 100 years or until the damages have been collected. So that's another warning. Now the full power of the legal enforcement system. The full power of the legal enforcement system. can be brought to bear to collect the damages owed by the accused. The sheriff is empowered to seize paychecks, cars, homes, anything and everything necessary to fulfill your indebtedness to me, or etc. Loss of government employment. The accused is in fact a convicted felon, unbondable by any insurance company or surety company, subject by law to immediate termination if employed by the government, and forever barred from holding public office, because they have an oath of office, and if they break that oath of office, they have no office anymore. So therefore it's their bond and their swearing truth under penalties of perjury and treason that makes the office and can revoke them the position in office, if you see what I'm saying. Because it's the bond and the oath that makes everything. So these are primary things to ask for when you're in the court. Do you have an oath of office? Because I would like to see it on and for the record. You know? Because if you don't know if they have an oath of office, they can do anything to you if you just let them continue. You can't. And you have to question jurisdiction, which is contract or consent. Who gave them jurisdiction over you, especially when they're functioning through a foreign body of politics, a body of politics that are foreign to the body of politics of your land. You see, they're alien to you, and their laws are alien to you too. No wonder people on our land don't understand their laws and statutes, because it don't apply to us. We're not trained to know it. We made no promise to uphold it either, but they did. Jail time. The criminal complaint is turned over to the appropriate prosecuting attorney, who is processing you through, who must institute a sentencing hearing wherein a judge will impose the incarceration, jail time, prescribed in the appropriate criminal codes for the offenses of which the accused stands convicted. Should any such authority fail to prosecute sentencing against a convicted party, the mildest charge then faced by such authority is felony misprison. So should any such authority fail to prosecute sentencing against the convicted party, the mildest charge then faced by such authority is felony misprison. But such prosecuting attorney could also be charged with conspiracy to aid and abet the convicted party in commission of the same offenses. So if the judge and the prosecuting attorney refuses to prosecute the convicted, to prosecute the defendant, the guilty defendant, after all the overwhelming evidence and proof, then they also can be charged just as crucial and damaging as the defendant. You see what I'm saying? Because now they're injuring you too. So anyone who's injuring you is pretty much liable for termination of office or criminal charges, criminal penalties, or things along that line. Because no one in the system is above the law. You see, and we're all under and equal to the law. So if we're breaking the law applies to us as well. It doesn't matter who you are. And you can't hide behind fictitious titles and nice looking uniforms and costumes. That doesn't make you not liable for your own responsibilities as a human. Especially when you're dealing with cause and effect. So I hope you guys see what I'm saying. Under our current political situation, politics, where the enemies of the people often occupy positions of power and authority, and those same people can prevent or slow the wheels of justice, there are still many ways to publish the convictions and misdeeds of parties so convicted that can be even more humiliating to the convicted than the normal methods of publishing the results of their conviction. So you may want to publish this stuff and make a report about this for the public through newspaper or whatever way you can. Summary. The fundamental purpose and one of the major objectives of the commercial affidavit process is to educate wrongdoers to the fact they have abused the unalienable rights of a sovereign, natural free man or free woman on the land, and cannot get away with it, and to give them an opportunity, commercial grace, opportunity to cure, to repent, to feel bad about what they did and ask for forgiveness, and undo the wrongs they have done. Unlike the typical criminal trial where the accused no longer has the option of simply redressing the wrongs he or she has done, the commercial affidavit process, CAP, does give the accused that option. So unlike the typical criminal trial where the accused no longer has the option of simply redressing the wrongs he or she has done, the CAP does give the accused that option. Further, the CAP is designed to educate wrongdoers that they are being used by the conspirators in the war against the people. Thus they may see for themselves what is really going on and decide which side they choose to serve. Role of the courts. An affidavit is someone's solemn expression of truth. An affidavit is someone's solemn expression of truth. You may want to put that in your affidavit as well, somewhere in the beginning. The foundation of the law, commerce, and the whole legal system consists of telling the truth. I swear to tell the truth, the whole truth, and nothing but the truth, so help me. Either by testimony, deposition, and or by affidavit. Every honorable judge requires those who appear before him to be sworn to tell the truth, and is compelled by the high principles of his profession to protect truth and do nothing to tamper with that truth, either directly or indirectly, either in person or by proxy, or by subordination of an affiant or other person. Alright. A judge cannot interfere with, tamper with, or in any way modify testimony without disintegrating the truth-seeking process in his sacred profession and destroying the fabric of his own occupation. To do so abrogates the First Amendment, the right to speak, the right to religion, the right to question and to find the truth, which was established to protect truth. And a lot of them are exercising their Fifth Amendment right, which is their right to remain silent. So you have the right to speak and you have the right to remain silent. It is committing professional suicide as well as inviting countless civil and criminal repercussions. Any judge who tampers with testimony, deposition, or affidavit is a threat to the commercial peace and dignity of the county, state, and United States of America, the country, thereby violating the laws of all those political subdivisions and acting in the nature of a foreign enemy agent. A mixed war, trading with the enemy, working with the enemy, aiding and abetting the enemy, almost like being a spy. That's a big crime, high crime. Justifiable subject to penalties of treason. So thereby they are violating all of the political subdivisions and acting in the nature of a foreign enemy agent, justifiably subject to penalties of treason. Big crime. Big crime. They're afraid of that word. We will not be committing treason today, I am pretty sure of. Am I right? Hopefully we're not going to be committing treason today, my honor. Where's your oath of office? Whoever acts against commercial affidavits without executing the necessary commercial paperwork under affidavit, sworn testimony, is subject to being charged criminally. Said charges begin with fraud, which is gaining at the expense of the loss of another, using trickery or deception or lies, or color of law, or legalese. And the charges expand from there to include all those violations that extend to and are a natural outgrowth of such fraud. Commercial processes are fundamental, non-judicial and prejudicial. Remember that. You can write that in your affidavit as well. No judge, court, law, or government can invalidate these commercial processes. In other words, an affidavit or a lien or a complaint based thereon, because no third party can invalidate someone's affidavit of truth. To act against such affidavit is to create a situation and or enhance the condition of a mixed war. No one can rebut an affidavit except a party, for example, a lien debtor, who alone by his own affidavit must speak for himself if challenged. Only someone himself knows his truth, has the right and responsibility to assert it. So only someone himself or herself knows his or her truth and has the right and responsibility to assert it. The mixed war situation and or condition is that where those in authority have violated their oaths of office, violated the fundamental law they took an oath to uphold and protect, violated the codes, statutes, and regulations that govern them thereby. They disregarded the peace and safety of the community by their actions, acting for undisclosed foreign agents or governments against those whom they swore to protect. So see Black's Law Dictionary on war. Black's Law Dictionary is the lawyer's dictionary, their dictionary. Also the Wicked's dictionary. Simply an act or acts of treason is a secret war against the people. So I would read this again if I was you. The mixed war situation and or condition is that where those in authority have violated their oaths of office, where those in authority have violated the fundamental law they took an oath to uphold and protect, where those in authority has violated the codes, statutes, and regulations that govern them thereby, and those in authority have disregarded the peace and safety of the community by their actions, acting for undisclosed foreign agents or governments against those whom they swore to protect. Therefore, they're committing treason. Notes on the above article. What you have read give you the theoretical foundation for most of this manual. Commercial liens. Practically. Practice practically. Train practically. There are difficulties with the strategy described above. Conducting a common law criminal trial is not easy, as the author noted. The court system has, for practical purposes, extinguished that option. Common law, the law of the land, contract law. Thus, territorial gangsters are often shielded from criminal prosecution. However, one aspect of the strategy that can still be effective is commercial liens. As of this writing, it seems that no judge can extinguish such a lien if it is properly executed. Constitutions as enforceable contracts. The commercial lien strategy depends upon one maxim as its linchpin. The idea of a constitution as a specific performance contract between a governing official and the people in a particular jurisdiction. That specific performance contract is the particular jurisdiction, is a specific jurisdiction. Therefore, if they are breaking the performance contract of the United States of America, which is the Constitution of America, or the contract of America, or the agreement between the people and the government of America, then the jurisdiction would be the Constitution. The fact that they broke the Constitution and have broke that contract, whether they didn't have that contract directly with me and you or not, they made it with we the people in general. So you count, you matter. Your voice is just as valuable as the people who were alive back then, who originally made these specific performance contracts for the government to obey and perform. So some writers, such as Lysander, Spooner, have denounced the United States Constitution as a fraud on the grounds that it is not an enforceable contract. See report number TL07, The Constitution of No Authority, available at this website. Well, I'm not sure what website they're talking about, but go to Yahoo or Google and type this in to the search box. The Constitution of No Authority. The commercial lien strategy, by contrast, holds that constitutions are enforceable contracts. The instruments of contract, oaths of office. So it is an instrument of contract, and it is a form of a commercial lien, and it isn't a constitution that is enforceable or enforceable contract. What is oaths of office? The commercial lien strategy assumes that when an official signs an oath, she signs a contract to exercise the powers of office within the limitations of the Constitution and the laws. Remember the specific performance contract, because a contract, it clearly specifies what you're supposed to perform, what you're supposed to do. And remember, performance almost like making a play or doing a play. You put on a costume, you play the role, and you play your part, and blah yada yada. You know what I'm saying? So they're literally performing. It's all performing. It's all like playing house, a game of house or a game of doctors, or the game of the legal system, of cops or whatever you want to play. Everyone's in costumes and they're performing because they contracted to put on those silly looking costumes and wigs. The commercial lien strategy assumes that when an official signs an oath, he or she signs a contract to exercise the powers of office within the restrictions and limitations and boundaries and the scope of the Constitution and the laws. On paper, these are sanctions against officials who violate their oaths. Quote unquote, whoever having taken an oath before a competent tribunal, officer, or person, in any case in which a law of the United States authorizes an oath to be administered, custodian, willfully and contrary to such other states, or subscribes any material matter which he does not believe to be true, is guilty of perjury, and shall be fined no more than $2,000 or imprisoned not more than 5 years, or both. Title 18 United States Code, Section 1621. So Title 18 USC, Section 1621. So whoever having taken an oath before a competent tribunal, officer, or person, in any case in which a law of the United States authorizes an oath to be administered, willfully and contrary to such oath, states or subscribes any, whoever willingly and contrary subscribes any material matter which he does not believe to be true, is guilty of perjury, and shall not be fined more than $2,000 or imprisoned not more than 5 years, or both. Title 18 USC, Section 1621. In practice, it is very difficult to prosecute a malfeasant public official. And by the way, I would put this on my affidavit as well, to let them know if they commit perjury, they'll be in big trouble, because they're under a performance contract, a specific performance contract, which is their oath of office in the Constitution of America, or the Constitution of your land. However, such officials may be exposed to great personal, commercial liability for violating their oaths of office. Apparently, many government officials realize this. Alfred Adask, editor, publisher of the Anti-Shyster, writes, a friend of mine recently asked the Texas Secretary of State for copies of governors and AG's oaths, but received no response for nearly 2 months. 2 months. requesting for a copy of the governor and the AG's oath of office. Finally, he received a copy of the AG, Dan Moral's oath, which was dated January 1991, but was not file stamped until March 26, 1993, which means it wasn't official until 3 years later, or 2 years later, pardon me. Very suspicious. Very suspicious. Governor Ann Richards' oath is yet to be found by the Secretary of State. That's pretty fishy. Likewise, very suspicious. Very fishy. Why ain't anyone questioning these things and making sure they have these oaths of office? It's our responsibility, or they're going to take the system from us. It appears probable, that the governor and AG had not taken their oaths of office for 2 years after they were elected. If so, they were or are probably in office illegally, which means they're in office de facto. They're in a de facto status because it's not factual that it's legal that they're in office. They shouldn't even be in the seat that they're sitting in as leaders of our system if they don't even have an oath of office to become initiated into our system and club. You see? So that means their contract and their positions null and void. They may be a pirate. They don't belong in the sea. It would follow then that anything they'd done or signed in an official capacity in the last 2 years might also be unlawful, null and void, and without legal merit. Without legal merit. Everything needs merit. They're committing meritless crimes, meritless actions, dishonorable actions. The potential for legal havoc could be huge. Laws signed by the governor during the last 2 years might not be lawful, which means people can get out of jail because the official that was in office was not actually official and they didn't have oath of office. So it can change everything. It can change everything. So when you raise up these questions, you're pretty much waking up the hornet's nest, if you see what I'm saying. And you're also sending the hornet's nest on them because it's exposing them. It's exposing the truth, and the truth shall set you free. The truth shall set everyone free and bring light. That's the whole meaning of the return of Christ. Yeshua is the return of truth, the return of light, not the return of flesh. It's the return of truth, because we've been living in a lie for so long. The entire executive branch of the Texas state government might be without lawful authority to enforce any law or any regulation. Innumerable criminal convictions might be reversed. All of the criminal court cases prosecuted by Attorney General Morales, AG, and the entire Attorney General's office, which derives its authority from the AG's oath, from the Attorney General's oath, might also be unlawful. Of course, it's virtually impossible that the courts will rule that all official acts of Texas for the last 2 years are unlawful. They're not going to want to go through that mess. They just continue in corruption, continue on with the mess, and just act like it never happened and it's not there. So everything is, because we're not seeking for justice and we're not punishing these people and correcting them, they're getting out of hand. They're getting very out of hand, and we need to get these officials back on the right track again, or we're pretty much doomed. Alright, let me see. But whether those official acts are bogus or not, there is an infinitely more important question. Why weren't the oaths of the governor and attorney general of Texas, the two most important officials in the executive branch of our state's government, on file at the Secretary of State's office? So if you want to look for their oath of office, go to the Secretary of State, because the Secretary of State is the one who's supposed to be watching over these documents and protecting them and guarding them and stuff like that, and putting them on file. So why are they in office if they haven't had an oath of office pretty much properly done in the Secretary of State's office? Properly implemented, properly signed, or properly administered, or properly registered with the Secretary of State's office. Something's wrong. Maybe the Secretary of State is also involved with this corruption. That would be big. That means the police is corrupted. You're trying to find justice in the court through the judge and the prosecuting attorney or the attorney general, but then the attorney general, the judge, and the prosecutor all work together with the public attorney and the public defenders and all that stuff. So they're breaking the law. None of them got an oath of office, yet you go through the Secretary of State to look for their oath of office. No police have oath of office. The judge don't have oath of office. The lawyers, the public defenders, they have oath of office to be on our land. No license to be on our land. No permission, no contract, no jurisdiction, no anything. How about the Secretary of State? How can the Secretary of State just let this happen and don't protect the truth and all this stuff? So the Secretary of State might be involved in the corruption as well, because they probably don't have an oath of office. And if they don't have an oath of office, how the heck can the chief executive officer, the CEO, or the president allow such people to do what they're doing, or Congress? And then come to find out, Congress don't have an oath of office, president don't have oath of office, Secretary of Treasury don't have oath of office. No one has oath of office, but they have populated in our society. They're everywhere in our society, acting as our officials and authorities and our God. And on top of that, without even a contract on top of that, which makes it worse. So everyone in the system right now may not have an oath of office, and we may be dealing with extreme threat, extreme terrorist acts. Why? Some sort of clerical error? Right? I don't think so. I think the oaths were missing because they didn't exist. Emphasis added. So perhaps some officials simply choose to be oathless in an attempt to cover their butts from being sued because they didn't make a promise to be or take a risk, or leaned on for not upholding and defending the state constitution. Could be. It's their attempt to cover their butts from being sued or leaned on for not upholding and defending the state constitution. So bonding of government officials off ice. Bonding of governing mentalities off ice. Officials. Some pro se or pro per litigants postulate the requirement that government officials be bonded. As far as anyone knows, this theory has not been tested in court. Nonetheless, some readers of this manual may wish to research this topic further. Therefore, what follows is a brief exposition of the theory. The bonding theory states that most elected officials and government administrators, perhaps even lawyers, are legally required to be bonded, contracted. That is, they must purchase a performance bond, a kind of insurance policy which guarantees the official will perform the duties required by his office. Where is your performance bond? Because most elected officials in government administrators, even lawyers, are legally required to be bonded. Where is your performance bond? Where is your insurance policy, which guarantees that you will perform the duties required by your oath of office? In the event the government official fails to perform his duties, any party injured by this breach of contract can recover the cost of his damages from the bonding company. According to these pro per and pro se litigants, despite the legal requirement that government officials be bonded, many, perhaps most, or maybe all, are not. Therefore, the bonding requirement strategy is based on first determining if a given official is legally required to be bonded. Then if he is bonded, and evidence can be shown to the bonding company that he is failing to meet the performance requirements of his bond, the bonding company or insurance company may revoke the bond, the contract, or raise his premium, which should help encourage the wayward official to obey the laws. Further, if the bond is required by law in order to hold a particular office, once that bond is lost, it's possible that the office must also be surrendered. If the bond is required by law in order to hold a particular office, once that bond is lost, it's possible that the office must also be surrendered. If the official is not bonded, then the lien process includes notifying the government official of this legal deficiency. If he does not correct the deficiency, purchase a performance bond within 90 days, then anyone damaged by his actions can file a commercial lien on the government official for all of his personal property. And make sure you let them know that on and for the record. They have 90 days to purchase a performance bond or to furnish or prove or evidence their performance bond or any actions that they may make or take after that 90 days can be used against them to recoup damages, to recoup financial or monetary value for damages or torts, wrongdoings, whatever it may be that they're doing. Intentionally injuring you, accidentally injuring you, whatever it may be, they'll be liable for it after 90 days. And let them know that you're going to place a lien on all their personal and private property as well if they do injure you. Because no one should be injuring anyone or the person owe you. Also, according to this theory, a government official's bond is dependent upon his legal immunity. And that immunity is to some extent is based on having a legal oath of office on file, usually with the Secretary of State. So they have no immunity if they're not registered with the Secretary of State. They're just like anybody on the street that threw on a wig or a police suit and they're injuring you. They try to judge you or arrest you or something like that without even having proper document on and for the record and on the file. So they definitely have no immunity if they have no contract or no bond to be working here in our state and in our system. If his oath of office is insufficient to meet the constitutional or statutory requirements, he may lose his immunity in his bond. If he loses his bond, he becomes personally liable, lienable for any illegal act he commits in office. Chapter 3. Basic concepts of liens. What is the definition of a lien? A lien is a claim, encumbrance, or charge on property for payment of some debt obligation, or duty. Qualified right of property, which a creditor has in or over specific property of his debtor, as security for the debt or charge, or for performance of some act. So, Black's Law Dictionary, 6th edition, page 922. Here's some emphasis added. A lien is a public declaration of commercial debt and or obligation. So it's a public declaration, public notice, like the UCC is a public, international public notice. And your county recorder deed office, it's also your public record, your local public record. UCC is international record, public record. Debt usually refers to money or property. Obligation usually refers to the fulfillment of specific performance. Examples include the fulfillment of oath of public office or the provision of the tax finance due process, as in the provision of a jury trial instead of a summary process. Examples of liens include, if you don't know what summary process is, look that up. Examples of liens include mortgages and automobile loans. In both instances, the possessor has the right to use the property. However, he may not sell or otherwise alienate the property without first satisfying the lien. Any attempt to evade the lien is known as pound breach, which is a felony in most jurisdictions. So you might want to write down your affidavits too. Any attempt to evade the lien is known as pound breaching, which is a felony in most jurisdictions. You may not sell or otherwise alienate the property without first satisfying the lien. Make sure you put that in there too. So the possessor has the right to use the property. So they have the right to have the title to the property and all that stuff. But the title does not mean that you have a claim on the property or anything like that. A title is a title, a claim is a claim. So if someone have a claim on you and or your property, even though you are the possessor and you have the right or the legal title to the property, you cannot sell the property or abandon the property or the payment without first satisfying the lien. So technically, the person, the lien holder, has equitable title over the house, which means they're getting paid. They're the ones who are benefiting from the house financially. But the possessor is the person who just has the title. They own the house. They just have title over it, but may not have the equitable title. So it's best to also have the equitable title of the house. So all money that's supposed to be being paid for the house goes to you instead of someone else or a third-party intervener. Because you don't want to just possess the house and have the house. You want to also have a lien over your house. And the lien would mean you have equitable title on that house, on that property. And if anyone wants that house, they have to buy it from you. So equitable title and legal title is two different things. Or equitable interest in financial interest compared to title interest. All right, let's continue. I hope you guys are getting what I'm saying. An individual who has no debt, no need to borrow money, and does not contemplate selling or refinancing his house or car can probably live with the lien for a long time. However, most people, especially most government officials, do not fall into that category. So an individual who has no debt, no need to borrow money, and does not contemplate selling or refinancing his or her house or car can probably live with a lien for a long time. Therefore, even though a commercial lien does not cause outright forfeiture of property, it can still cause significant hardship. Even more vexing to the lien debtor. And plus, when you put a lien on someone, you're clouding up their title, their equitable title and stuff like that, their legal title. Because now no one can buy that house or deal with that house until that lien is paid off. And when you send this to your county recorder's deed office, they put it on record that the house has a lien on it, you see? So no one can touch that house after you put that on public record. So even more vexing to the lien debtor is the fact that the lien is not causing him any actual damages. Rather, it prevents him from doing that which he may want to do. Therefore, suing the lien claimant or the lien creditor or lien creator for damages is not easy, provided that the lien has been properly executed. Types of liens. Common law liens are non-commercial lease pendens, common law liens that must be upheld by judicial action and a court before claims to assets can be executed. Common law liens are usually used more in a defensive way to shield and protect assets rather than an offensive way to lay claim to assets. See further discussion under comparisons. Equity liens arise from an equity court or administrative or bankruptcy or financial court, commercial court. Statutory liens. Statutory is a mix of commercial and admiralty. It's based on the sea and is commercialized as well as militarized. So it's commercial military admiralty or commercial pardon me. Hold on, let me see. Admiralty. Okay, so it's commercial maritime admiralty. Because maritime means war, martial law, war, the military, merchants. Commercial means merchants, sellers and buyers. And as you know, commercial means business. It also means business. So they're business or militarized businesses of the sea, of admiralty. Commercial maritime admiralty. That's what statutory liens are. So they're foreign, they're commercial, and they're militarized. Very aggressive. They are established by the statutory laws of the state. Mortgage liens are created by contract between borrowers and lenders, creditors and debtors, with the assets of the borrower pledged as collateral to the lender. So that's what a mortgage lien is. Mechanics liens are typically used by repair service providers as a claim on an item repaired to ensure payment for repair services rendered. So if you get your car fixed and you don't pay the repair, then they can place a lien on your vehicle and car to fulfill that indebtedness. And that's why they have you sign those papers and those contracts when you go to the mechanic as well. And the mortgage people do this as well. And you pledge your house as collateral willingly. You can reverse all of these though, because contract rules the land. And if they didn't give you full disclosure, the contract can be nullified. It can be terminated and stuff like that. If it isn't a bilateral contract and it's a unilateral contract, it's nullable. You see, you can nullify it. It's voidable. So the name originated from when an auto mechanic repairs a car and the owner fails to pay for the repair. Then the mechanic can file a lien on the car. Commercial liens, also known as contract liens, are true bills, receipts, evidence, proof in commerce, publicly declared. A true bill in commerce always contains and is characterized by a one-to-one correspondence between an item or service purchased and a debt owed. This commercial relationship is what is known as just compensation. This commercial relationship is what is known as just compensation. Fifth Amendment, United States Constitution. A normal true bill in commerce is private, whereas a commercial lien is publicly declared. Using means such as media advertising and or filing at the county recorder's deed office. When it is uncontested by a categorical point-by-point rebuttal of the affidavits, it is considered an account, receivable, security, assets. Title 15 U.S.C. So in general, commercial liens, for example, mechanics and workmen's liens. So if you clean someone's yard and they don't pay you for cleaning up the yard, you can place a lien on their house and property as well. And this is usually how people get houses for free and stuff. They clean the house. If they don't get paid for it, after they sent them the affidavit with an invoice stating how much they owe them, they can place a lien on the house and place in the county deed office and take the house. So in general, commercial liens take seniority over common law liens, which in turn take precedence over mortgage liens. Tax liens are classified as commercial liens because there's tax liens as well. If you don't pay your tax, someone else can start paying your tax, and if you eventually don't pay the tax off during the redemption period, the time to cure, opportunity to cure, then the person who's been paying your taxes can place a lien on your house or take your house from you, literally. You see, tax deeds and tax liens, and are classified as commercial liens. Tax liens are classified as commercial liens, which is why they are so troublesome. Comparisons. Common law liens are well known in the sovereign community for asset protection. They are considered non-commercial because they do not contain a declaration of one-to-one correspondence between an item or service purchased and the debt owed. So common law liens are well known in the sovereign community for asset protection. Thus, they don't represent true bills in commerce. Common law liens don't represent true bills in commerce. You're just stating that you have a claim on this, you have a claim on that, but sometimes you have to go through the court in order to argue that, to see if what you're saying is true. So common law lien will be a natural law lien. A lien where you're just writing on paper, hey, I have an interest on this car or this thing and it's mine. But there's no true bill or anything or any type of purchase or one-to-one correspondence between an item or service purchase or a debt owed. Commercial liens is based on strictly debtor and creditor. Common law liens are just based on word of mouth, of truth, of heart. So because of that defect, a non-commercial lien must be adjudicated by a court of common law before the asset can be claimed by the other party, and is therefore known as a lis pendens lien. Lis pendens lien. The commercial value of a lis pendens lien rests upon the outcome of the pending litigation. Hence, it is a security, an asset, an interest, but is not an account receivable until it is adjudicated as such. So common law liens are normally used as defensive shields, and that by placing it on one's own asset to be protected, no other party can legally get access to the asset without first challenging the lien in court. That's why it is called a lis pendens lien. The lien might be filed at a county recorder and never be challenged in court, because parties who have no just and legal right to the property will usually avoid the risk of failing to prove the claim in court. It is considered asset protection, since it is difficult or impossible for anyone to get at the equity in an asset. If a lis pendens lien of sufficient size has senior position. A commercial lien, by contrast, is offensive in nature, in that it declares a legal right to someone else's asset as a debt owed as a one-to-one correspondence with an asset that was given. It is not a lis pendens lien because the exact value is already specifically determined. So it's not a lis pendens lien because the exact value, the receipt, the proof, the invoice is already specifically determined, consistent with the laws of commerce. It is a true bill in commerce. Although a commercial lien can be challenged by a common law court or by a Seventh Amendment jury trial, it does not require a court process or a court judgment for its establishment, validity, or effectiveness. A commercial lien may not be removed by anyone except the lien claimant or a properly convened, properly conducted jury trial, due process. It may not be removed by a summary process. A summary process is too vulnerable to bribery, kickbacks, and fraud of process. Like the common law lien, the commercial lien can be filed by common natural law men and women, or free men and women on the land, without the aid of expense of a lawyer, a liar, and without the approval or interference of the courts, middlemen, third-party interveners. It's not between you and them. They're not a party in the case. They're not a real true party in the case, or real true party of interest in the case. You do the necessary research. You fill out the lien. You have it notarized, and you file it with your county clerk. It's simple, inexpensive, and so powerful. It can give a common person an enormous amount of legal leverage that is largely beyond the reach of the courts. In some counties, among the thousands of counties in the United States, you may find recalcitrant clerks who will refuse to file your properly executed documents, while such clerks are violating their sworn public duty to record and make a matter of public record your properly executed documents. As a practical matter, suing a recalcitrant country clerk or county clerk usually will be less effective than various alternatives. So as a practical matter, suing a recalcitrant country clerk usually will be less effective than various alternatives. Your best bet is probably 1. Be low profile in recording any properly executed good faith documents. Don't particularly discuss the contents of the documents you're filing with the clerk. You're not trying to hide anything. After all, you're making a matter of public record various statements you are affirming the truth of in good faith. But attracting undue attention may impede the process of anything. You may wish to make a matter of public record. 2. If you do run into a recalcitrant clerk who doesn't like what you're doing, simply try another county or try the same county on a different occasion. This fits very well with our strategy of creating your own creative alternative when confronted with certain bureaucratic obstacles. You can also send it certified mail and registered mail with or without signature, because you can request for the recipient's signature too. It's best to get their signature because then you know someone there got the paperwork, which makes them super liable. You could, as a different alternative, try using appropriate media publications to make your documents a matter of public record by publishing the documents. You'll need to research the particulars of how to do this in your area. If you use this option, you can also make a website and put it up on there as well, because everything on the internet is public record. Everything you put on there becomes public record. No matter what you're doing on there, even job applications, public record. Worldwide record. But finding a county clerk that does their job routinely and properly is probably low profile. So unlike the common law lien used to defend the property you possess, A commercial lien is offensive in nature since it enables you to attack, threaten, or seize someone else's property which you do not possess. The fundamental difference between commercial and common law liens centers on the issue of possession. In many states such as Oklahoma, a common law lien can only be filed against property which you lawfully possess. This was decided in Oklahoma Supreme Court case Williamson versus Willingham 186 P2D, page 2D, 644. This is the reference right here, the Oklahoma Supreme Court case. You might want to check that out. So a common law lien can only be filed against property which you lawfully possess. Check the laws in your own state. A commercial lien, by contrast, can be filed against the property of anyone who owes you a financial debt or duty of performance, regardless of whether you possess their property or not. Liens versus levies. Levy. A seizure. To seize. The obtaining of money by legal process through seizure and sale of property, like forfeiture, foreclosure. The raising of the money for which an execution has been issued. The process whereby a sheriff or other state official empowered by writ. Know how to create your own writs. Writing. Or other judicial directive actually seizes or otherwise brings under her control a judgment debtor's property which is taken to secure or satisfy the judgment. Judgment debtor's property. Black's Law Dictionary, 6th edition, page 907. So the sheriff, you can use the sheriff to directly seize the property or otherwise bring it under your control. So where you can control it. So rather you're able to control the house than just have title of the house. Because he who controls the house pretty much can do what he want to do with it. Even if you have the documents for it and all that. If you don't know how to enforce what you have and what you know, it's not yours. So you got to know how to claim what's yours properly and protect it, because it's your asset. It's your portion. So a levy is the outright seizure of a property and satisfaction of a debt or obligation. A lien, on the other hand, is an encumbrance on property. Although the two often accompany one another in judicial or commercial actions, they are not the same thing. Exempt from levy. Chapter 4. Procedures and implementation. Research. First, obviously, read everything in this manual and anything else on the subject you can find. While this manual provides all the most important basic information, it does not presume to possibly cover comprehensively everything you would ever need to know on commercial liens. New information is coming out every day, and you may discover additional information from your own research and experience. Further, because Terra Libra is not in the business of giving licensed legal advice, nor me, even this manual cannot be relied upon as your law. This is simply information we believe to be accurate, and it is your responsibility to confirm that it complies with the laws in your state to protect yourself. It is assumed that you will already have specific purpose in mind for the use of the lien. You either have had property taken by officials and government-related agencies, which you would like returned, or you have otherwise been damaged by their specific actions or failure to fulfill their obligations in office, or you have some large ideological goal you would like fulfilled for the benefit of society at large, like Mr. Marsh's lien against the United States government. Whatever the case, much of the language of the documents to be used will have to be composed by yourself from your heart with your own words to articulate the necessary factors for the fulfillment of your chosen purpose. That doesn't mean you can't use a template with, a basic foundation on it already, with words on it already. Just make sure you switch the words with your words and gain the overall concept of what you're doing. You see, because it's very simple. It's really not that narrow. Notice and demand. The first document you will be creating is the notice and demand. It is imperative that this step be included before filing the lien. Otherwise, if this step is skipped, you could be prosecuted, convicted, fined, and or jailed for failure to follow legal due process. Properly following due process is part of your actions being done in good faith. After an errant official has been served the notice in demand, he must be given a lawfully adequate period of time. Check your local jurisdiction's requirements to correct his error or breach of contract. Usually this is anywhere from 30 to 90 days. For example, there was a notice in demand reportedly served by Charles Gray, a pro se, to Judge Joel Feldman in Georgia. See Appendix B1. In this notice, Mr. Gray alleges that Judge Feldman had broken various laws in the process of taking of some of Mr. Gray's property to repay back taxes to the IRS. Although you can use ideas from Mr. Gray's notice and demand, obviously your own must be custom designed for your own purpose. So your own situation must be custom designed for your own purpose. Yet there are certain common elements that should always characterize it. 1. It should be in the form of an affidavit, and it should address the individuals personally. Legal notice and demand. Public announcement. 2. The notice should be as concise as possible, preferably avoiding religion or morality. It should focus on applicable law you can apply, and contain appropriate citations of law. So reference the laws where it says that they can't do what they're doing, and the Holy Book would help out in doing that as well, because the Holy Book states, do unto others what you want others to do unto you. A workman's worthy of their hire and stuff like that. And you can use their own statutes and the Constitution, everything that you can to make these people wake up. They're an illusion. If possible, to support what is being claimed. 3. It must quote the legal amount of time given for the recipient to fulfill the demand, and what will happen if the demand is not satisfied within that time. 4. It should give the recipient a certain period of time in which to rebut the claims made therein. 5. Finally, it should be hand-delivered or sent certified mail with return receipt requested. So notice of default. After they haven't rebutted your affidavits, and after they haven't your affidavit of notice and demand, or your affidavit of counterclaim, or whatever your affidavit may be about, because the affidavit could be about anything. Affidavit of accurate books, affidavit of true report, whatever it may be. You can make affidavit about anything. You're the creator and creditor. Notice of default. If the individual does not respond to or rebut your notice and demand, see Appendix B.1, you should then send a notice of default, or notice of dishonor, or a notice of non-response. It depends on the situation. Notice of non-response, notice of dishonor, notice of default. Stating that 1. The recipient has acquiesced to your claims by default, which means they had accepted the claims. Acquiescence means acceptance. The recipient has accepted or acquiesced to your claims by default, and that too, payment or satisfaction is expected now. Filing this notice of default, see Appendix B, Section 2, with the county recorder or clerk of court where the lien debtor has property creates a public legal record in support of your subsequent lien. So I'll also send one to the IRS too, possibly. Definitely. Commercial lien. If, after the lawful period passes without correction, only then can a commercial lien be served to the offending official or sent certified mail or registered mail. Certified mail is for public, to keep it public. Registered mail is to bring it into the private. With return receipt and signature requested. And also filed at the courthouses for the counties in which the offender has property. The lien must be accompanied by or must contain a commercial affidavit containing a ledger of damages suffered. The lien must also cite the laws, actions, or obligations that gave rise to the damages. Models of both documents are listed in Appendix B. So lawsuits and criminal complaints. Some pro per litigants will first file a lawsuit under Title 42, United States Code, USC, Section 1983. Title 42, USC, Section 1983. Or a criminal complaint before filing a commercial lien. This step is included to show a good faith attempt to obtain justice according to normal legal procedures. After the courts refuse to consider the litigant's legal complaint, which is usually the case, the litigant declares a state of mixed war and files the commercial lien. So you would declare a state of mixed war through affidavit as well, stating that the court didn't want to take your paper or accept your paper. They refuse. They're working with the enemy. You declare that you're in a state of mixed war, or this is a mixed war. And file the commercial lien, because now you're at war. You're trying to free yourself and gain remedy and a cure, and these people just keep stepping in your way. Alright, so let me see. Alright, we're going to stop at page 30. Alright, so chapter 5, mistakes and pitfalls to avoid. Defective legal form and, let's finish up right here. An example of a criminal complaint is included in Appendix B.4. If you use it, you must change the document to suit your particular situation. There is no fill in the blanks magic here. Chapter 5, mistakes and pitfalls to avoid. Defective legal form and procedure. When filing any lien, it is important to follow the legal forms and procedures of your state or locality. Study the statutes for the locality in which you are filing and follow those forms and procedures religiously. Failure to do so can have serious consequences. First, you may be civilly liable for slander of title. In some jurisdictions, notably Louisiana, this is called jactitation, a suit to remove the cloud of title and recover damages is known as an action of jactitation. So a suit to remove the cloud of title and recover damages is known as an action of jactication. Even worse, in many jurisdictions, someone who files liens in bad faith or who uses defective forms or procedures can be convicted of felony slander of title. An example of the possible repercussions is shown in the following newspaper article. Headline: on March 3rd, 1933, front page of the St. Louis Obispo Telegram, Tribune. Bogus lien filer convicted. When Sheriff Williams tried to refinance his home, a routine check of county records showed someone had placed a $100,000 lien on the home. The lien was filed by Stephen K. Jones, whom Sheriff Williams had never seen until they met in court on the issue of the lien. Jones defended himself without a lawyer against charges he filed the bogus liens against property owned by Sheriff Williams and 6 others who were involved in the sale of his truck conducted by the Sheriff's Department to collect a portion of the $22,000 in back taxes the Franchise Tax Board says Jones owes. Franchise tax. Liens were also placed on property owned by the towing service operator who seized the truck and on the man who bought the truck at the tax auction. Jones later placed that man under citizen's arrest for theft of this truck. So you can actually put people under citizen's arrest. You can arrest somebody literally as a member of your own state, of your own country. A co-owner, co-member. Jones is one of what law enforcement authorities believe is a loosely affiliated group of county residents who call themselves common law citizens, people who take extraordinary steps to disavow government control in their lives. Jones has a notarized document renouncing his citizenship, affidavit renouncing his citizenship as a U.S. citizen or U.S. incorporated citizen or 14th Amendment citizen or 15th Amendment citizen, whatever you want to call it. Renouncing his citizenship, because that is part of your status change as well. You can't be sovereign and be free and be a voter and a citizen of a state or a sovereign citizen at the same time, or a sovereign's citizen or a sovereign's member or a sovereign's groupie, whatever you want to call it. You have to be purely just sovereign, natural, free man on the land, and propria persona. Sui juris. Sui juris. So he has a notarized document renouncing his citizenship, has taken steps to void his birth certificate, because that's the other thing keeping us trapped. Relinquish his driver's license and social security number, because all those are contracts that's keeping us trapped. We can't be trapped and try to act like we're not trapped at the same time. And close his bank account, because the bank card he believes gives the bank power of attorney. Jones' 2 sons, 13 and 12, sat with his wife throughout the week-long trial. They're taught at home and don't attend school. I like that. That's how I think. I have 2 small children who I want to see grow up and not be slaves to the government, he told the jury. But the prosecuting attorney said Jones went too far when he filed official-looking documents, the liens, for a $17 filing fee. According to the prosecutor, the documents were just garbage. What Jones did is hardly a prank. Liens are a ticking time bomb, said one expert on real estate law. The victim doesn't even know it exists. Once a lien is recorded, it remains on the books forever. Having a lien nullified, even one that's fraudulent, requires a court order. That process likely involves hiring an attorney and could take anywhere from months to years. A jury convicted Jones on 2 felony charges after deliberating less than an hour. The maximum punishment is 3 years in prison on each count and a $75,000 fine. Outside the courtroom, Jones admitted that recording the liens was a mistake. He couldn't tell the jury. Jones confided, but he regrets what he did and blames advice from a Sacramento-based anti-tax organization, which he paid $3,200 to join. He used documents supplied by the anti-tax organizations to file the liens. Emphasis added. Evidently, Jones did not substantiate his liens with a true bill in commerce, which means he never even gave them the proper notice of in demand, an invoice, an affidavit of claim. He didn't do any of that necessarily. He just went ahead and just did liens. Lien. You can't do it that way. You have to go through the steps in the process. That's the due process. So he did not substantiate his liens with a true bill in commerce, nor did he serve the sheriff et al. With the proper notice in demand, a commercial grace. He didn't even give him 30, 90 days to, place a lien on them. The prosecuting attorney used both of these facts as evidence of bad faith and easily obtained a conviction. Let that experience be a lesson to others. Don't use this material unless you are very sure you know what you are doing. And any actual results are your own responsibility. The procedures discussed in this manual and video are not to be used for fun. Consider them to be an academic interest only if you're less than fully sure in good faith of what you're doing. You and you alone are fully responsible for any results that might arise from any actual use of these materials. We specifically disclaim any such responsibility. Alright, the Hansen type. The Hansen type, or nebulous liens. In the 1970s, a man named Gerald Hansen started filing liens on various government officials whom he regarded as corrupt. According to Hartford Van Dyke, a current exponent of the commercial lien strategy, a current exponent of the commercial lien strategy, Hansen's liens were nebulous. Apparently, Hansen did not connect the official's misconduct with any specific monetary damages, because you need to associate the misconduct with a monetary damage, a monetary value, because that's what creates a receipt. That's what creates a receipt, a transaction, a charge, a purchase, and stuff like that. Because their wrongdoing to you is a purchase, and you have to charge them, which becomes evidence and proof or a receipt or invoice that they owe you money based on what they done to you, based on what they purchased, in other words. So you have to look at it like that, especially when the officer orders you to do something. Is that an order, or is that a request? Because if it's a request, I do not consent. If it's an order, I conditionally accept your order if you pay me $10 per hour. And if they do it anyway, that means they accepted the contract and they purchased something from you. And now you're connecting that misconduct with a specific monetary damage, with a value which you suffered. In other words, they were not true bills in commerce. Therefore, judges ruled that these liens were lease pendens liens, common law liens, rendering them subject to equity proceedings. That, of course, defeats the entire purpose of the commercial lien strategy. A lien seems more likely to stand if a specific official violated his or her oath of office, resulting in a specific and identifiable damages to you. Hansen-type liens and class action liens, such as Phil Marsh, stand on a shakier foundation. Let's hear about Mr. Phil Marsh now. Aiming too high. Many proponents of the commercial lien strategy have filed liens like Phil Marsh upon the President of the United States, the Secretary of the Treasury, state governors, and the like. Whether or not such liens are legally accurate, they create a credibility problem. First of all, did the president, for example, damage you by his specific actions? Damage you? If not, your lien has a weak foundation, and you can't be using YouTube and conspiracy theories, all that stuff to sue the president. You would have to have proof yourself, or if you find it online, and bring that proof with you at least, or something. Most likely, if it's not if you have not been directly injured, you're not considered an injured party in the case. Whoever been injured would have to sue. You can't sue on behalf of your fellow peers. And remember, although the president's evil and he works based on deception, if he haven't deceived you, then you're not an injured party still. You would have to be directly injured by his actions. If not, your lien has a weak foundation. Second, if you file such a lien, you may temporarily get the attention of the public official and some headlines, but you ultimately risk looking like a crank. It's true. Rather than aiming to win big, you may be more effective filing $10,000 or $100,000 liens on minor officials like IRS agents who have less public sympathy and are easier targets. Judges and sheriffs are more difficult, but not impossible. In the case of a judge or a sheriff, it may be advisable to get more notices of demand than you technically have to. This shows good faith and gives the other party a chance to correct the fault. So be advisable to give more notices of demand, probably 2 or 3 of them, and then hit them up with 1 default or 2 or 3 notices of default. And after that, that's enough. That is enough. File your lien. Execute your lien. Alright. Beware of exotic arguments. Another double-edged sword is the insertion of books like Silent Weapons for Quiet Wars as evidence for a lien or a suit. The question here is not one of merit but effectiveness. Can you win with such evidence? The answer is it depends. Dr. Gene Schroeder of the American Agriculture Movement appealed a case last year in which he submitted evidence that the federal court's admiralty jurisdiction was obtained by a written declaration of war upon the American people, enacted by Congress March 9, 1933, 48 Stat 1. He states that 2 federal judges involved with the case retired, shortly after the appeal was over. So, yes, it can work. However, the risk of this approach is obvious. Unless your evidence is very strong and you or your lawyer have superb presentation and speaking skills, you risk looking like a mental case if your action ever comes in front of a jury. It's true, because the jury don't know what you know. The jury are not competent. The jury aren't educated about what you're saying. So you got to constantly make sure you give definitions for what you're saying and your intent. Make your intent clear. State it on it for the record, because the jury is your peers. They're going to judge you, you see. And if they think you're crazy and they can't get what you're saying and they can't find evidence or proof of what you're saying, most likely they're going to think you're a liar. Not the judge, not the plaintiff or whoever, the accuser. So be careful. Make sure you are very clear and articulate in the courtroom and on your paper, and keep things simple. Very, very, very simple. Straight to the point. Matter of fact, just target the main major things that matter the most. Everything else should fall into those places like dominoes. So the key here may not be legal but psychological. You need to have an accurate measure of your opposition. If your exotic evidence is strong and you can scare off the prosecutor with an embarrassing issue, then it may be effective. However, if your opponent is psychologically more secure than you, that may not work. To put it another way, what you can frighten a prosecutor or a judge with is one matter. But what you can convince 12 people in a jury box to believe may be quite another. So juggle that, balance that, and remember that. Before you use such evidence, either in a lien or in court, you should take an honest inventory of yourself. Do you have the psychological acumen, the strategic thinking skills, and the rational, reasoning courage, which does not cross the line into recklessness and disrespect and all that stuff, no breach of peace, to effectively use this evidence. If so, well and good. If not, you may wish to use more conservative strategies. Know yourself and know your enemy, and in 1,000 battles, you will never be in peril. Sun Tzu, The Art of War. Alright, so we're going to pause right here for now. We're right here on page 30 pretty much. And we're going to continue from chapter 6, our obstacles and strategies for overcoming them. How to overcome certain things when it comes to liens and filing the affidavits and avoiding pitfalls and stuff like that. Well, I hope you guys enjoyed this video. Come back and join me on part 3. Have a wonderful day, and may you continue to live in peace, joy, love, and prosperity. Shalom, all of y'all. Ahaya bless you. Amen.